Hello, here today we are going to present on the analysis report of Beckers versus Albert, which is highly focused on the area of laws and court history in the decision making. In this report, I am going to present the introduction part of the case. Ranbir Singh is going to present the facts and issues raised by the Beckers and Albert by the appellant and respondent. Tejvinder and Shivam going to present the both issue 1 and 2 in the order of respondent and appellant. After that, again I am going to present the judgment of the both issue 1 and the Ranbir Singh in the judgment of case 2. This is the issue related to the duty of care occurred by an occupier to his visitor, which was heard by the judge Garling DCJ in the trial, who decided the case in the favor of the respondent, and then the appellant appealed this case in the New South Wales court. Now Ranbir Singh going to continue with the facts and issues of the case.
The fact of this, the applicant was the owner of the swimming pool. The respondent had been swimming in the pool with the applicant's permission. Unfortunately, one day the incident happened in which the respondent injured seriously. After a swimming session, the respondent decided to leave, and so he climbed up the ladder attached to the pool. When he reached to the platform, he turned around and allowed himself to descend with the ladder facing the pool wall. As he was a heavy person and he maneuvering the platform, he fell toward the ground and seriously injured. Now the issue raised by the applicant and the agreement respondent. The principal issue in this case was the having a breached duty of care of the applicant as the occupier of the premise. The first question is his platform was unstable due to indicate tightened bolt, and the next one is the failure to inspect the maintenance of the ladder and the platform. Now the engineer giving the argument on this issue as a respondent.
Now I will represent the issue of as a respondent. They claim that the platform was very wobbly, that's why she fell down on the ground. It was further submitted that the platform was unstable because bolt was not properly tight, and expert evidence also proved that there were 5 to 6 degree gap between the platform and the pool combing, and which would cause of platform to flex under load, thus becoming unstable. And now
as an applicant argued by respondent testimony that the platform was unstable, he came out of the pool, was questionable because the respondent did not feel any instability on the same platform when he went into the pool. In the event, the platform was found unstable. The applicant denied it was due to inadequate tightened bolts.
and issue 2, since the platform was unstable, the respondent argued that the applicant should have to fix pool combing. It was claimed that the applicant had failed to discharge his duty of care as the occupier of the said premises.
There was no obligation on my part to inspect the platform. As such, the applicant submitted that he was not negligible for having ignored the existence of the defect of the platform. The applicant argument was primarily premised on two decisions, namely Short v. Barrett and Stennis v. Graham.
Now there is a critical analysis on the judgment of the issue 1 by the Court of Appeal. Our group is on the view, after seeking all the issue 1 and 2, had highly decided that issue 1 is in the favor of respondent. In this case, both parties adduced conflicting testimony on the stability or lack of the platform. The trial judge Garling DCJ have to decide which version of the testimony is more probable. Then the judge preferred to choose the respondent testimony first. It's on the decision to do so, and the court's refusal to interfere in this case. Then the respondent will win this case. The respondent has successfully discharged his honor of proof by sufficient evidence. This show against the appellant without offering the lots of evidence. Now, again, Ranbir will going to clarify the judgment too.
In the second issue, the court decision in the favor of the respondent. The court agreed with the trial judge. There was a gap between platform and the combing. This was the indication that platform was in danger condition. As a reasonable person should inspect and fix the platform where it is necessary. Our group agree with the court finding that the applicant was liable for this injury suffered by the respondent. Now the conclusion is going to present by the Shivam.
To conclude our group case study, it clearly shows that this case imposes an obligation on an occupier to inspect his premises to avoid defect that may pose physical injuries to the visitors. As an occupier cannot escape liability by simply pleading that he wasn't knowledge about the particular risk, it is also questioned that have occupier taken proper measures to avoid those risks. Failure to do so that have breached the duties and thus be suspected to liabilities. Thank you.
Thank you.